Today, dated 30th October 2017. Present, Amadou Samba, the applicant. Mary A. Samba, counsel for the applicant. Ami Bensouda, counsel assisting the commission. Ruling. Consequent on the deliberations by the said Commission of Inquiry, assisted by counsel to the Commission, the Commissioners on 13th October 2017 made suo motu 2 interim orders which are annexed to this ruling. The first order is the one commencing with the name Muhammad A. names Muhammad Bazi, Fadi Mazegi, and the applicant Amadou Samba as board directors and or substantial shareholders in some of the 20 companies listed in the order. By order A, the applicant Amadou Samba, Mohamed Bazi, and Fadi Mazegi are restrained A, including shares, stocks, debentures, or other interest in any of their companies or businesses in the Gambia or outside the Gambia, pending the further order of this commission or the outcome of this inquiry. B, whether by themselves or their officers, agents, or any of them, or otherwise howsoever, to apply, meaning that they are free to apply to the Commission of Inquiry for the variation or complete discharge of the said order. Upon such an application, backed by legal as follows: the assets of 3, the assets of known family members and close associates that are out of the jurisdiction are hereby frozen pending further orders of this commission. 4, members of the public are invited to provide any information they may have regarding assets owned by such persons in or out of the country, and such information shall be treated as confidential. 5, the above named persons are at liberty to apply. 6, the order shall be published in national newspapers of wider circulation. I consider it noteworthy that of the 17 persons affected by the said orders of the Commission, only Amadou Samba, the applicant, has put in an application. This was notified to the Commission by letter dated 20th October 2017 by his solicitor, Mrs. Mary Abdoulaye Samba. Paragraph 2 of that letter reads, quote, unquote, I intend to move the Commission on certain applications before the Commission on the interim orders made against my client dated 13th day of October 2017 and served on my client and an order dated 13th day of October 2017, published in the Standard newspaper, Point, and other newspapers circulating in the Gambia. There was and is no objection to the form the application herein took, since the commissioners announced at the very start of its public sittings that the notice of motion and affidavit in support would rarely be admitted, because unlike oral application, it has a proclivity towards protracted legal tussles which would benefit no one. Notice was earlier given to the applicant to move his application on 25th October 2017, and on the date he said counsel, Mary Samba, in the presence of her client, announced her representation and argued his case as summarized below. According to Mrs. Samba, her client, Amadou Samba, had been summoned to appear before the Commission as a witness. He spent time with the Commissioner's investigators, but before he actually appeared before the Commissioners in open session, he was made aware of the two said orders of the Commission, one of which was served on him personally, and the other through newspaper publications. Counsel for the applicant, Amadou Samba, clearly stated her single prayer regarding the Commission's orders A and B, to wit, that the orders be discharged on several grounds. The grounds are: 1, that under Section 205 of the Constitution, the applicant is entitled, quote, to the same immunities and privileges as if he or she were a witness in proceedings before the High Court, unquote. Counsel did not elaborate on this point. Nevertheless, it seems to be implied that the said immunities and privileges ought to have been granted to the applicant, but were not. 2, that no formal notification was given to the applicant prior to the issue of the orders, thus depriving him of an opportunity to react by cross-examination of witnesses who testified that he was a close associate of the ex-president. 3, that there should have been a public hearing of the matters giving rise to the said orders. 4, that a rule of natural justice, to wit, audi alteram partem, was not complied with by this Commission in the same manner that the Commission fundamentally breached the Constitution of the Republic. applicant's counsel referred to Section 24 of the Constitution, particularly the provisions as to fair hearing. 5, that the Commission went beyond the terms of reference. See Legal Notice number 15/2017, issued and gazetted by the President of the Republic, in particular the paragraphs thereof specifying the authority of this Commission of Enquiry. Therefore, applicant's counsel submitted that the Commission acted ultra vires, that is, beyond its powers, by making the said orders, which are, according to her, quote, unquote, enforcing rather than recommendatory. 6, that Section 202, subsection 2, paragraph D, allows this Commission to make interim orders only in relation to witnesses' attendance or the production of documents. Asked by the chairman of the Commission whether she had anything to say on the matter, counsel assisting the Commission, Mrs. Annie Bensouda, submitted that the interpretation of the constitutional provisions on interim orders was misconceived. Interim orders are permitted even in a court of law, as can be seen in orders 11, 12, and 13 of the rules of the High Court. However, it must be noted that the Commission has original jurisdiction to issue interim orders, but may look at court procedure only by way of analogy. The power of the Commission to make interim orders is unlimited. Counsel assisting the Commission also submitted as follows. 1, that Amadou Samba, the applicant, though a witness, has been found and named by the Commission to be a close associate of the ex-president and subject to interim orders. 2, the Commission has jurisdiction to make ex parte orders by analogy and deal with the matter without, in the absence of the applicant otherwise. Its orders might be nugatory, since a witness knows that an injunction could be made concerning his assets, would naturally take steps to dispose of them. 3, the constitutional provisions should be interpreted purposefully to give practical effect to them. 4, the witness can hardly take the position that he was not aware of the proceedings of the Commission, which have been extensively published in newspapers, television, social media, and radio. 5, the interim orders themselves put the applicant on notice, and he had every right to challenge any order, since he had liberty to apply as stated in the orders themselves. 6, there was nothing stopping the applicant from having access to the documents and transcripts of testimonies, which are all in the public domain. At the beginning of her argument on the oral motion, counsel for the applicant, Amadou Samba, informed the Commission that the sole relief she was seeking from the Commission was the discharge of the said interim orders A and B. At the end of the address, she was asked by the chairman what reliefs she was asking for, and the unequivocal answer was, quote, the discharge of the interim orders, unquote. Clearly then, the application of Amadou Samba was not for the variation of the said orders, but for their discharge. Counsel did not put forward any suggestion as to the issues that call for the termination of the application herein. We shall proceed on the following issues for determination. 1, whether or not this Commission acted ultra vires contrary to the Republican Constitution and or the law of the land. 2, whether for any legal or factual reason the interim orders A and B ought to be discharged. These are the 2 issues for determination. The 2 issues for determination are herein considered together and not one by one. However, before delving into the issues, it is believed that a short historical backdrop to the legal foundation of commissions of inquiry should assist our deliberations and facilitate the understanding of all persons concerned. On 22nd July 1994, the AFPRC, that is to say, Armed Forces Provisional Revolutionary Council, staged a coup d'etat, established a military dictatorship, and sanctified the slogan, accountability, transparency, and probity, quote unquote. The APRC quickly passed several decrees, later converted to parliamentary acts. for the issuance of commissions of inquiry and for the freezing and forfeiture of assets linked to mainly public officers strongly suspected of unlawfully acquiring public funds and or landed properties. The said decrees / acts are still existent in Cap 2901, Cap 2902, Cap 2903, Cap 2904, and Cap 2905. The first of them having been passed in 1994, that is to say, the Public Assets and Properties Recovery Act. It is important to note that it was not the APRC that introduced the Commission of Enquiry to the Gambia. The first Commission of Enquiry, still in the statute books, is the Commission of Enquiry Act, Cap 3001, which was passed during the colonial era in the year 1903. That is to say, 114 years ago. That statute is extant and binds this, our Commission of Enquiry, to the extent that it is consistent with the 1997 Constitution of the Republic of the Gambia. In 1997, the Constitution was passed. All the acts mentioned above predate it, but it is the Lord of all laws in the Gambia, although in some other countries the supremacy of Parliament is the norm. The jurisprudential dichotomy inherent in the Gambian Constitution, where it is the supreme law of the land and at once the foundation of all laws, where it is at the top and at the same time at the bottom of all laws, is a mystery only to the uninitiated. Suffice it to say that Section 4 of the Constitution reads, quote, "The Constitution is the supreme law of the Gambia, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void," unquote. In dealing with the said interim orders under attack by the applicant's counsel, I should from the outset remind myself of the practice backed by judicial pronouncement of this of saying very little on the facts in this interlocutory matter in order not to prejudice the proceedings of the Commission, especially when Amadou Samba, the applicant, is yet to complete his testimony. Be that as it may, it is considered useful to raise and reaffirm certain facts emanating from the face of the interim orders themselves, taken as a whole, to wit, one, that Amadou Samba, like others named therein, are considered close associates of ex-President Yahya Jammeh. 2, that over $200 million and over 10 million US dollars have been lost to the government of the Gambia and the people of the Gambia, and investigations are still ongoing. 3, that the applicant had or has interest in several of the listed companies. 4, that it is necessary and or prudent to avert the risk of these persons, the applicant included, disposing of their assets or reducing their value pending the completion of this inquiry. As clause 17 of the interim order A puts it, it is evident that the Gambia is a highly indebted poor country. Therefore, the stated sums of lost money are colossal.